Perhaps the biggest mistake people sometimes make when creating their estate plan is not funding their living trust. What does this mean, you ask? Simply put, a trust must actually hold your property in order for those assets to pass to the beneficiaries of your trust. That means that a trust will not be effective if it doesn't contain anything. Thus, for example, the title to your bank accounts, stock certificates, real estate, and the like must be transferred into the trust. So how does this occur? Well, the grantor of the trust must actively change the names on assets he or she owns. So deeds must be prepared on real property, signature cards need to be changed at banks, and stock certificates must be reissued, all into the name of the trust. How do people fail to complete this all-important step in their estate? Most commonly, it occurs in one of three circumstances. The first way mistakes happen are when people try to complete the trust themselves and get confused, or go to incompetent planners who don't know what they're doing, and the trust winds up never being funded in the first place. Another real common way trusts remain unfunded occurs when people refinance their home and they take their house out of their trust to complete the refinancing, but then forget to put it back into the trust after the loan has been made. And finally, a third way this mistake happens is after people create their living trust, they acquire new assets, such as a new home or stock account, and they don't remember to put these new assets into the name of their trust. So please remember this incredibly important aspect to having a legally valid living trust, and make sure it's funded. Incidentally, in the living trust created here at the trust store, a provision is added to your trust which should allow assets to be put into the trust after you pass away. Still, to fund a trust in this manner will require a court order under what has become known as a Hagstad petition. And of course, funding a trust after the date of death with a court order will be time-consuming and expensive, as well as totally unnecessary, since the whole procedure could have been avoided if the trust were properly funded in the first place. But at least the possibility to carry out your wishes through the living trust still exists. If, however, large assets outside of the trust are unable to be placed into the trust for whatever reason, a probate will need to be opened to transfer those assets. If you already have a trust and are unsure if it's funded, please schedule a free initial consultation here at the trust store, and we can discuss your matter.